welcome back to part 2 of the United States Supreme Court. The Supreme Court, if you recall, exists as the highest court in the United States. There is no court higher, and its decisions cannot be appealed. And the precedents set by the court have the strength of law. All right, so how the Supreme Court says a law should be interpreted is how that law must be interpreted. That makes the Supreme Court an incredibly powerful tool in shaping how our nation functions, how it works, how our laws are carried out, who we are as Americans, which means a lot of people want to influence this. A justice's decisions are influenced by a lot of things, including, and most importantly, their interpretation of U.S. law, which means that in every single case, a justice is going to have to think carefully about those laws, how they should apply, how they have applied, and what we should do going forward. The precedents of past Supreme Courts are extremely important in doing this, as is the actual text of the Constitution. This is the most important influence on a justice's decision in any case, is how they interpret the United States Constitution, how they read that document, and how they believe it should apply to laws in general. Now, presidents are going to influence the court in one essential way, and that is they nominate candidates who will closely share the president's view. So when President Barack Obama nominated Elena Kagan and Sonia Sotomayor, he nominated those two justices because they look at the Constitution, they look at constitutional issues in a very similar way to how he sees them. But once they are on the court, the president has no control. They have no influence. Sotomayor may decide cases in a way that President Obama would not. But he can't change that because once she's there for life. So how do you change the court? Well, throughout periods, the Supreme Court has shifted in its opinion, shifted in its main view of its own role. And it's done so based upon who are the justices at the time. And generally, when the Chief Justice of that court is the leading voice of the majority of the court, we tend to name that court after that justice. And we have eras like the Warren era. And today we are in the Roberts era of the court. So how does a court look at the world? How does a court look at its role? Well, there are two main ways that a court looks at it. Activism, judicial activism, or restraint, that is judicial restraint. Now, some, such as Chief Justice Earl Warren, very influential Chief Justice for a very long time, believed that the court should take an active role in shaping policy. He believed that the United States Supreme Court, its role was to drive the nation forward on important issues. And by doing that, they interpreted the Constitution in a way where they saw it as a flexible document. A document that should be shaped and interpreted based upon the world around them and how it currently existed. And this is judicial activism. Now, right after Warren, we had kind of a response to Warren with Chief Justice Warren Burger. I know this is confusing. We have two different Warrens. One is the last name. One is a first name. This is the Burger Court. So we had the Warren Court. Now we've got the Burger Court. He believed that the court should avoid overturning laws, that Congress's role was to write laws, and that the judicial branch of government, whenever possible, should avoid the overturning of that. And they should rely more on the actions of Congress and established law in the Constitution than reinterpreting things to fit specific situations. That is the idea of activism versus restraint. Activism is a flexible view of the Constitution. Restraint is a concrete view of the Constitution. All right. The court and other branches of government. Judicial review, if you remember judicial review, this is a system of checks and balances where the court has the power to declare things unconstitutional. It's an important power. Judicial review has given the court that important check. And it's a check over both the executive branch and legislative branch. This should say legislative branch. I apologize for that. Important check over those two. Some believe this power shouldn't be allowed. It's not in the Constitution, right? Judicial review was Marbury versus Madison. It wasn't the United States Constitution. Some argue that we should just throw it out. But others believe that without this power, the legislative and executive branches of government would assume too much power to themselves, that this is the most important check on what they can do. So what are the president's powers when it comes to the Supreme Court? Well, president's most important check on the Supreme Court is his ability to appoint new justices. He shapes the direction of the Supreme Court, whether it's activist or restraint. He shapes that direction through his appointments. So if he thinks that the court has become too activist, if the president believes that the court is doing too many things to shape policy and it's not their business, they should stay out of it, leave it to Congress, they're going to appoint a justice who practices judicial restraint. And the opposite is true. They believe the courts need to be more active in protecting the rights of citizens from the encroachments of government power. We need to have an activist judge who's going to get in there, and the president will appoint the correct person. Now, some presidents, however, don't ever actually get this responsibility, because a Supreme Court opening and appointment only happens when somebody dies or retires. And these people can serve 20, 30 years. So sometimes a president just never gets to appoint a single justice. Sometimes you get to appoint many. Barack Obama had 3 vacancies during his presidency. He could have, and some would argue should have, been able to appoint 3 justices during his 8 years. He did appoint 2, and the United States Senate chose to force a vacancy in the court for what will be well over a year by the time it's filled, in order to give that appointment to a different president. So powers of Congress. Well, Congress checks the Supreme Court in 2 ways. Number one, they can refuse to appoint a Supreme Court nominee. That's what they did with President Obama. He nominated somebody named Merrick Garland. They refused to even consider appointing Merrick Garland to the United States Supreme Court. They would rather wait until after the presidential election and then try to give that appointment to President Trump, which is what they did, and that's what will happen. That's how the Senate can check the power of the Supreme Court. Number 2 is Congress has the power to amend the Constitution, to nullify the court's argument that something is unconstitutional. That's a power that Congress has. If the Supreme Court says, you can't do that, that's unconstitutional, Congress can say, all right, well, constitutional amendment, check, done. Now it's constitutional, isn't it, Supreme Court? That's their power. That's how they can check the Supreme Court. But apart from that, there's not much Congress can do. There's not much the president can do. Once the justice is in place, they've got a lot of power, and they've got it for life. Well, how do we get involved in this? What's our influence on the court? Well, we've got basically none. Citizens don't get much of a say in what the Supreme Court does or how it rules. We have very little influence. All we can really do is influence the court by electing presidential candidates. If we choose a dramatically different presidential candidate, as the United States did in 2016 when they voted in Donald Trump, we are going to get a different kind of justice, a different kind of Supreme Court from a Donald Trump nominee than we would have gotten from a Obama or Clinton nominee. And in this way, the citizens do get to shape the court. But instances like that are uncommon, and people don't generally vote for the president just through the view of the Supreme Court, although certain people certainly do. But that's all we get to do. We cast a vote for president in the hope that a president will appoint a certain Supreme Court justice. Other than that, the Supreme Court can completely ignore, and does completely ignore, what the public wants. That is their right, and some would say their responsibility within this system. That is all for today. I hope you learned something. Thank you for joining me, and farewell.